STBB in Somerset West. And what we're going to have a look at this morning, just some tools with regards to resolving disputes when purchasers occupy a property before transfer takes place. I know you all will probably have a story about something that happened when a purchaser occupied the property early. Then they find defaults in the property and it's a juggling act, keeping everybody happy, etc., etc. So that's exactly what we're going to have a look at today, just to see how we can manage this. And the first thing that we're going to have a look at that I find the best way to manage it is actually prevention is better than cure. So if we have a look, I'm going to move it manually. There we go. So prevention is better than cure, which means that it is so important to explain the legal consequences of the offer to purchase, how certain clauses are worded, because if people understand right from the outset what their obligations are, then we don't have to deal with a lot of these challenges that pop up at a later stage when they occupy the property. So, for example, when you have a look at the occupation or the possession or transfer clause in your offer to purchase, you'll see that possession and vacant occupation very often, and this is now just an example of a clause, but you'll have to have a look at your specific clause, but I'll pinpoint what the important little things is just to have a look at and explain that to prospective sellers and purchasers so that they understand. Okay, so the occupation clause, very often it will say that the possession and vacant occupation. So the clause will read, possession of the property shall be given and taken on registration of transfer of the property, from which date all the benefits and all the obligations of ownership in the property shall pass to the purchaser, and from which date all the risk in the property shall pass to the purchaser. So that is very important. Possession, risk, in this specific clause, says that it will pass on registration of transfer. So what happens if your purchaser occupies the property before the transfer is registered? In that scenario, your purchaser does not take possession or take transfer of the risk in the property. So if somebody drives through the wall of the property, or if there's a geyser that burst, it is still the seller's obligation to fix that, because the risk in the property, any damage caused at the property, risk in the property, only passes according to this specific clause on registration of transfer. So in this specific clause, we need to advise the seller, listen here, Mr. Seller, the purchaser is taking occupation early, but you must just remember that the risk in this property still stays with you. So if there's a geyser that bursts or anything happens, or if a neighbor on a Friday night at 12 o'clock doesn't take the corner to his driveway fast enough, whatever, and he drives through your wall, the risk is yours, despite the fact that the purchaser is occupying the property. In terms of the clause of the contract, the risk will pass on transfer. So please, Mr. Seller, keep your homeowner's insurance in place. So if anything happens at the property, the geyser burst or something, the neighbor through the wall, at least you've got homeowner's insurance, because you will be liable to repair that, because that's what the contract says. Again, this is one of the issues that might arise when the purchaser has taken occupation of the property. Then there's a geyser that burst. Now the seller wants to know, but why am I now there's a dispute? Why am I as the seller liable now to go and fix the geyser? I'm not even staying there anymore. The purchaser is staying there. I'm not going to do this. Then you have to go back. You always have a look at the contract. we have to go back to the seller and say, Mr. Seller, look in your contract. In terms of the contract, risk in this property only passes on registration of transfer when the property is transferred to the name of the purchaser. So now from occupation until the property is actually transferred, you still carry the risk in the property. So if the geyser burst, then you must repair it. And then you find out that the seller is obviously very upset. He might have cancelled his homeowner's insurance because he didn't have a bond on the property. Look, if he's got a bond on the property that will be cancelled on transfer, then he's got insurance on the property. And then it's an easy little problem to solve. But let's say he didn't have a bond. And now in his mind, on the day of occupation, when the purchaser moved in before the transfer registered, in his mind, well, I'm going to cancel my homeowner's insurance. Why must I pay it? No, but Mr. Seller, look at the offer to purchase. The agreement says that risk passes on transfer, not occupation. So you should have kept your homeowner's insurance. So to avoid that scenario, to avoid that dispute, it's important that the parties understand when risk in the property will pass from the seller to the purchaser, who's liable to maintain homeowner's insurance. So for example, let's say that the risk passed on occupation. That's absolutely fine. Then the purchaser must understand, Mr. Purchaser, as from when you get the keys, you will be liable for the risk in this property. So if this geyser burst or if the neighbor drives through the wall, the risk is with you, Mr. Purchaser, because that's what the offer to purchase says. The offer to purchase in this scenario says that the risk will pass on occupation. So, Mr. Purchaser, you must make sure that your insurance is in place. Obviously, with taking out insurance on somebody else's house is not always possible. And in that scenario, the purchaser or the agent or the attorney will request the seller to just maintain his homeowner's insurance. The purchaser will reimburse you your monthly premium for your homeowner's insurance. But at least the purchaser knows that, yes, risk has now passed to me. When I got the keys on occupation, I'm liable if anything happens in this property. If it burns down, I'm liable. So, Mr. Seller, please maintain your homeowner's insurance. I will, over and above the 10,000 Rand occupational rent that I must pay, you know what? I'll pay the 600 Rand for your installment for your homeowner's insurance. But these are the things that you need to discuss with your seller and your purchaser in order to avoid the dispute at a later stage when the purchaser has taken occupation before the transfer takes place, and now something happens to the property could burn down, the geyser can burst, anything can happen, and then there's a fight as to, well, who's now liable in the risk? Who must now pay to have this fixed? And it will be in your contract. Your contract will say who's liable to fix the damage that was there from occupation until transfer. If there was any damage in that little space, your offer to purchase will tell you who's liable, because it will say the risk or possession and risk in the property will pass on either occupation or the registration of transfer. And the parties need to understand who's liable for what. Because if they've got a clear understanding, then there's a very slight risk of a dispute arising at a later stage when the purchaser does take occupation, and if there is damage at the property, if they from the outset knew who's liable for damage or risk in the property as from occupation, it's sorted. The problem stops there. So the clauses go on. The seller shall, up to the date of registration, keep the property in the same condition that it is on the day of signature of the agreement, subject to reasonable wear and tear. So again, the seller must maintain the property until the day of transfer. Very often a purchaser will occupy the property, and then he might occupy the property 2 months after making the offer to purchase, after viewing the property. The pool was beautiful, The lawn was beautifully manicured. The garden beds were fantastic with rose bushes and all those lovely things. There were no cracks in the windows or anything like that. And now the purchaser moves into the property. Prior to transfer, the lawn is overgrown, the pool is green, the rose bushes have disappeared, there are some cracks in the windows, etc., etc. The seller must understand that, Mr. Seller, you must maintain the property until the transfer is registered. Yes, obviously, if the purchaser takes occupation before the time, then the occupation clause will then state that the purchaser from date of occupation will maintain the property, blah, blah, blah. But at the very least, Mr. Seller, you need to hand over the keys to the purchaser with this property being in exactly the same condition as when the purchaser viewed the property. So if your purchaser viewed the property and made an offer when the pool was green, the lawn was overgrown, then it's fine. No worries. He can have the keys in exactly the same condition as when he saw it and he made his offer. But you must maintain that property because very often again, purchasers will take occupation before transfer. They'll get the key, they'll go into the house, and then they'll say, no, but the seller did nothing to this property. From when I made the offer 2 months ago until now, there's a vast deterioration in the condition of this property because of the pool, the garden, the whatever. So it's important to explain to a seller, Mr. Seller, please maintain your property so that we don't have an argument, so that we don't have a dispute at a later stage when the purchaser receives the key. This property must be in the same condition as when he viewed it originally when he made his offer. So vacant occupation of the property shall be given and taken on a specific date or on transfer of the property, but we are obviously only concerned with regards to the specific date, if it's before the transfer. And from the occupation date, the purchaser will be liable for the payment of the occupational rent in the sum of, let's say, 10,000 Rand per month, which amount will be payable by the purchaser to the seller on the first day of the month or whatever they agree to. And that occupational interest, occupational rental clause is also very important. A lot of the disputes that we deal with is with regard, let's say, for example, the occupational clause read that 10,000 Rand per month. Now the purchaser takes occupation as from the 1st of November, pays the 10,000 Rand, no problem. And now at the end of November, the seller says, hey, I got the municipal bill at the end of November. There's water, there's electricity, all those lovely things. You must please pay this account as well. Then we need to go and have a look at what the occupational clause said, because very often that clause just says that the occupational rental of 10,000 Rand must be paid. That's it. Risk in the property will pass on transfer as from the date that the purchaser will be liable for the rates and taxes, water, electricity, all charges in respect of the property. So then we've got to go back to the seller and say, Mr. Seller, thank you for this municipal bill that you received from the municipality for November. Yes, your purchaser has occupied since the 1st of November. Yes, this water and electricity was used by him. But Mr. Seller, in terms of the occupation clause, it just says there that he must pay 10,000 Rand per month. It doesn't say that he must also pay for the rates and taxes, water, electricity, or just the water, electricity, or any municipal charges imposed. The rates and taxes will normally stay for the account of the seller. But the usage, like sewage, the refuse, the water, the electricity, the clause doesn't say that. The contract says that on transfer of the property, the purchaser will become liable for the municipal rates and taxes, water, electricity, all those things. So, Mr. Seller, we can't expect the purchaser to pay. Yes, I know that it is his usage, but we can't ask him to pay that because the contract doesn't allow for that. So in order to prevent disputes, that's why prevention is better than cure. Have a look at the contract. Have a look whether, as from the date of occupation, the purchaser will not only pay occupational rental, but also municipal charges for usages like sewage and electricity and water. Because if he does say that, then absolutely the purchaser must pay 10,000 Rand plus the municipal charges. But if it doesn't say that, if it just says that occupational rent is 10,000 Rand, that's it. And the clauses go on further to say risk will pass to the purchaser on transfer of the property. On transfer of the property, the purchaser will become liable for the municipal rates and charges. Then we can't hold the purchaser liable, therefore. So if the seller and the purchaser understands the clauses, what they're in for, it will prevent disputes at a later stage. Sorry, man, I skipped a little bit there. So if we have a look at the occupation clause, does this transfer, so does the risk in this property transfer on occupation, or does it transfer on the day of registration at the deeds office? It's important to have a look at that. It's got such a big effect on rates and taxes, on the risk in the property with regards to homeowners insurance, geysers bursting, etc., etc., etc. Ask the question and ensure that both parties are aware of the implications. Have a look at those clauses. Have a look when risk passes. And both parties need to understand to sort out homeowners insurance, what they're liable for, and who is responsible for paying the rates and levies during the occupation period. Again, your offer to purchase will say, as from date of occupation, the purchaser will be liable for the monthly levies, the municipal charges in respect to sewerage and refuse and water and electricity usage, or it won't say that. So it's important to have a look at the wording in the offer to purchase to see who's responsible for what, and that both parties understand it when they sign the offer to purchase. And trust me, I know. You've explained this to the purchaser and the seller 20 times, and when push comes to shove at a later stage, when they then act as if you've never discussed this with them. I do understand that, but we can only do as best we can to explain it and to hope that they do remember that you had these conversations with them. Again, ensure that all parties are aware what the contract stipulates to avoid any disputes at a later stage. Another way to prevent disputes at a later stage is the property condition report, obviously, that all sellers and landlords in respect of rental properties need to complete and provide to the agent. You know, it's a priority to have this form completed and signed by the seller, and encourage the seller to be as honest and open and transparent as he could possibly be in order to avoid situations at a later stage. This will avoid being accused of being dishonest or misrepresenting the truth of the condition of the property. This further avoids a situation where, upon occupation, the purchaser finds defects in the property and now threatens to delay the transaction or to cancel the transaction until the defects have been rectified, and threatens to cancel the agreement. So it's so important to have the discussion with your seller, to say, Mr. Seller, you know what? The more honest, open, transparent you are with the condition report, the better for everybody. Because if you complete it as to the best of your knowledge with whatever you know, it's going to be extremely difficult for a purchaser to turn around at a later stage and say, no, but look at this, look at that, I was never told about this. It's on the property condition report that the seller and you, Mr. Purchaser, signed. So if you didn't go through the property condition report and read it, then unfortunately, that's your indaba. We can't help you with that. And obviously the footnotes clause is also there, but again, The point of the footstoots clause is the seller and the purchaser must understand exactly what the footstoots clause means, because the footstoots clause states that the seller will not be liable for any latent defects, defects that you cannot see with the naked eye in the property. And the purchaser purchases the property as is. So, when you sign your offer to purchase, it's important to explain this. And I know you don't want to scare purchasers away and make them run for the hills when they want to make an offer. But it is important that they understand that the footstoots clause is there to protect the seller against latent defects and patent defects. But patent defects are the obvious defects that you can see. So that's an easy argument to have with the purchaser. Patent defects, it's always been there. That crack in that wall, if you have a look at the photos of the estate agent when he listed the property, that crack was there. You made the offer a month later. The crack didn't appear overnight since you made the offer. It has always been there. You should have seen it when you walked through the property. So the patent defects are lacquer. That's fine. But with regards to the latent defects that you cannot see with a naked eye, means that the seller will not be liable if for the defects that you cannot see with a naked eye, unless he knew about it and unless he didn't disclose it because he knew that he wasn't going to get the same price for his property, etc. But the purchaser must understand that look, the footstoots clause is there to protect the seller against latent defects that he cannot see, Mr. Purchaser. So walk through the property. We've got the condition report. The seller has disclosed everything that he is aware of. And if you, Mr. Purchaser, feel the need to instruct the independent home inspector, contractor, your brothers in the building industry, let him view the property with you. Let him go through the property with a professional eye as to see whether he could pick up maybe any defects that might be latent defects or caused by latent defects in the property. But the seller cannot be liable for such defects. And the purchaser must understand that, because very often, again, on occupation of the property, the purchaser complains about latent defects, like, for example, a leaking roof. A latent defect, we cannot see that the roof is leaking when we walked through the property. It was 30 degrees and I made the offer. There was no rain around. But now, when I took occupation, now I see, but there's a leak in the roof. So that's a latent defect. The purchaser must understand that you can only hold the seller liable if he knew about the leak and if he didn't disclose it because he wanted to defraud you, get more money from you. So if the seller can show that there's been tenants staying in this property for the last 2 years and they never told him, and the tenants confirm, but hey, we never told the seller about the leaking roof. We were just concerned that if we moan, he's going to kick us out of the house and we have to go and find another place to stay. So that's why we kept quiet. We never mentioned it to him. Then obviously the seller didn't know about it. And then the seller cannot be liable for that latent defect in the property. But again, purchasers, once they've taken occupation, they are fully aware that the seller is still the owner. But as soon as they see a little defect or whatever, they run to the seller to come and repair. But unfortunately not. The liability isn't with the seller anymore. It is with you, the purchaser, So again, parties need to understand what they're liable for and what you can hold the other person liable for and what you can't hold them liable for. That will prevent disputes in the future. So complete the property condition report and explain to the parties what the implications of the footstoots clause is. It's important to tell them, latent defects, well, maybe, but you have to show that the seller knew about it and that he didn't disclose it because he thought that he'll get more money out of you in respect to the purchase price. So when you've done this now, you've explained your contract You've gone through the occupation, you've gone through the occupational rental, who's liable for the rates and taxes, water, electricity, from what date, occupation or transfer, everybody's happy. Who's liable for the risk in the property, home energy insurance, guys, have we sorted that out? Yes, we're happy. You've done your property condition report diligently. You've explained the footsteps clause, who's liable for what, beautifully, everyone understands it. And there are still issues at a later stage that might arise and will arise. Obviously, not often, but they do arise. But then, okay, well, now we've tried all the preventative measures. What do we do now? So there are three common um, dispute resolution actions that you can take in order to resolve a dispute after the transfer or after occupation has taken place. But the same applies to after the transfer. But anyway, we're dealing with occupation in any event. So the three most common things are negotiation, sitting around a table and negotiate. I mean, we often do it. On Monday morning at 10 o'clock, I've got a meeting again with a seller and a purchaser and an agent to resolve a dispute or a little hiccup in the transfer. But that is what we do on a weekly basis. We negotiate, we sit around the table and talk. If that around the table negotiation doesn't work, then you can go to mediation, where you employ the services of somebody to mediate between the parties, and then arbitration as well. So with negotiation, the first step, obviously, it's the preferred option to use purely because it's informal. You sit around the table. You don't want to waste costs issuing summons and running off to court. So the parties have different positions, they've got different needs, they've got different expectations, and you need to identify that. You need to get to the nuts and bolts. Mr. Purchaser, what is the issue? Tell us what the issue is. What do you want to see happen here? Then we have a look at the contract. Mr. Seller, what do you see? So identify what the needs are, what the obligations are, and here both parties try to meet the interest of the other party. So it's always with negotiations, you try and meet halfway. You try to have a win-win situation. Both parties are not excited for getting a 100% win, but both parties are not distraught for not getting anything. So it's always a 50-50. It's always a balancing act. It's always a weighing up of the interests and trying to get to a solution. And normally, with a transfer of a property, you've got a seller that wants to sell the property, he needs to move on in life. You've got a purchaser that wants to acquire the property and is very excited about moving into the property with his family or whatever. So in a transfer transaction, normally we work with two parties that want to make something happen. They want to resolve the issue. They want, because both parties have got an interest in this transaction. The one wants to sell it, the one wants to buy it. And luckily, normally with regards to negotiations, they really want to compromise and to do whatever they can to meet halfway in order so that they can both achieve what they want to achieve in the property transaction. So both parties have legitimate needs, and it is possible to provide an outcome to meet those needs. The aim is to obtain a win-win situation for both parties. So again, with regards to dispute resolution and negotiations, the parties must attempt to do the following: recognize each other as a legitimate stakeholder, recognize the interdependence, accept that there's different overlapping and even conflicting interests in what they are trying to negotiate, have a commitment to change, have a mindset to try and resolve the matter. The parties must focus on the problem solving and solutions must be creative. Very often, for example, the home energy insurance, for example. Now, the offer to purchase it, that the risk will pass to the purchaser on occupation. So now, Mr. Purchaser, you are actually liable for the homeowner's insurance. So when the parties find out, oh, but I don't have homeowner's insurance, Mr. Seller, did you keep your homeowner's? Well, I've still got my homeowner's. Okay, I'll pay you more. I'll pay you a little bit extra a month, but just please keep your homeowner's insurance, so that if something happens, then at least there's insurance. And I'm the purchaser. If there's any damage, if the geyser bursts or if something happens here, then I will also pay that excess that you had to pay. I'll pay the excess. It's fine. So negotiate, compromise, try and trade between issues and needs and vague silence. Discuss the issues, focus on the issues, and stick to the issues. Keep a single text record of the issues and the needs of the parties. Identify the areas of agreement, what they agree about, and areas of disagreement. And then work towards a possible agreement with those areas that they don't agree on. Be open-minded, flexible, and good communication skills. Don't scream, shout, talk over each other. In this process, if this process fails, then the parties may attempt to resolve through mediation. So again, with regards to negotiation, parties will have to set up a meeting. Now, the parties can arrange it themselves. I always say it's better that the attorney is also involved. Just with legal aspects and not one party being bullied, etc. But okay, and it can obviously done. We've done negotiations via Zoom or whatever way, a conference call or whatever. The parties must then attempt to ensure that the meeting is civilized. Don't scream or talk over each other. Let one person speak at a time. Parties will then state their side of the story. Okay, Mr. Purchaser, you called this meeting, you unhappy. Please tell us your side of the story. What do you think went wrong? What do you want to see happen? What will make you happy? And then the solutions need to meet the interest of both parties. So it's a win-win situation. There's not one loser and one winner. Both parties must feel that they gave something up, but they also gained something from the negotiation. In practice, the parties usually agree and appoint a third party to act. That is normally in mediation. So when you go to mediation and the negotiations didn't work out for you, then you can go and mediate, and you then appoint a party to mediate, to resolve the issue. It's expected that the mediator use whatever techniques is necessary to assist the parties in the dispute, and cannot prescribe a settlement unless the parties agree to do this. So the mediator is preferably someone independent, that can sit down, listen to the stories, listen to the purchaser, listen to the seller, have a look at the offer to purchase, and come to some sort of suggestion as to how the matter is resolved. Whatever the mediator says is not a court order. The parties can say, no, we don't want to listen to you. You wasted our time and walk away. They can do that unless they've beforehand said, listen here, the purchaser and seller agreed. They meet and they say, listen here, we're sick and tired of fighting now. Let's appoint this independent mediator and let's agree. Let's shake hands. Whatever the mediator orders or decides, we're gonna go by that. Then absolutely. Then the mediator's decision or recommendation will be final. That is what the parties agree to. They agree to it in writing, that the mediator's decision will be binding on them. And that's fine then. It should be noted that the findings of the mediator are not binding unless the parties reduce the agreement to a binding contract. And then further, obviously, if the mediator made a decision, then the parties can sign an addendum to say, right, we've now agreed that the seller will repair the geyser despite the fact that risk passed to the purchaser on occupation. The seller will utilize his insurance to fix the geyser. The purchaser will be liable for the monthly premium of that month and for the excess, etc., etc., etc. Then reduce it into writing, sign it, and then the parties can move on. As an estate agent, acting as a mediator in disputes arising out of sale agreements, mediation techniques and elements may be helpful. If there's an independent estate agent with 20 years experience, an estate agent can be a mediator as well. They've got enough experience to realize the issues that may arise. They have dealt with this specific issue many times in their career as an estate agent, and they have seen how this matter could be resolved, etc., and can make suggestions as to how to resolve it. So an estate agent can also be a mediator and very valuable, as a matter of fact. So where the negotiation process fails, the parties will then have to seek help through mediation. So the person best suited for this role is somebody that is independent, that's unbiased, that's got no financial gain or financial interest in the matter, in either party, not related to the parties at all, and will be unbiased. Someone that is able to identify the key issues that need to be resolved and maybe focus on the key issues that need to be resolved without having a mediation or negotiation that carries on for a day. Know what the key issues are, and it comes through experience, and that is why an estate agent can be there, an attorney, but somebody with experience and someone with the experience in the property industry and a clear understanding as to the legal position and legal consequences of a contract, etc. So the options that you have as a mediator that you can call in would be an estate agent, absolutely, a housing tribunal, the conveyancer assigned to the transfer. I would suggest, my suggestion would be a conveyancer that is not involved with the transfer. If we've been through the negotiation process, the conveyancer would have been there while the parties negotiated. If that didn't work and you then want to go to mediation, where you get an independent mediator to come in, an independent estate agent with loads of experience, my suggestion would be an independent conveyancer should also come and sit. That's got absolutely no interest in the transaction. He'll be completely unbiased. I think that would be the best scenario. So estate agents, absolutely. Estate agents can be mediators. Yes, they act normally on behalf of the seller, but in the market they also act on behalf of lessors and tenants, etc. An important factor is that a skilled estate agent will have the experience and legal knowledge what is needed to negotiate a deal that benefits both parties. I mean, that is what you as agents do right from the beginning. When you sign the offer to purchase, you're already negotiating. So if a dispute arises, you've got the experience to negotiate and to see exactly what the stumbling blocks are and what the issues are that needs to be fixed and sorted out. So that is why estate agents with experience are absolute brilliant mediators. Even though estate agents act on behalf of the seller or the owner, they also add value to the buyer or the tenant, as they act as a link between the two parties in negotiations. That's where you negotiate the original offer to purchase as to what would best suit both parties involved, thereby fulfilling the criteria of possessing independent and unbiased qualities to negotiate agreements. The Rental Housing Tribunal, obviously the Rental Housing Tribunal is there. It will have principles that they will lay down as to how to resolve disputes. It is a very user-friendly way to resolve a dispute. Attorneys are permitted, but it's not necessary. The tribunal will have their own staff and employees that will assist the parties in coming to a meaningful solution to the challenges or the dispute that they are facing. This is only used in extreme cases, and it's something that everybody wants to avoid. I've never had a scenario where I even had to go to a mediation. You know, an issue should be resolved by negotiating, by sitting around a table, by sorting out having a look at the offer to purchase, see what the contract says, and sorting it out right there and there. Mediation, I've never had to do that, but that's the next option. A housing tribunal, etc., that is really the last option, and I don't foresee issues or disputes going that far down the road. Conveyancing attorney can also be a mediator. As I said, yes, absolutely, but we like to negotiate rather than mediate because the conveyancer usually has the right combination of knowledge with regards to the law, mediation, dispute resolution. We can be objective, but it would be, however, be advisable for the parties to seek a conveyancer that had not acted in favor of either one of these parties, so as to not prejudice the other party. And again, if you are the transferring conveyancer, if you are the transferring attorney, I wouldn't want to go to a mediation. I would love to negotiate, absolutely, that we can do around the table. But if you want to employ a mediator and you want to follow his advice and get a suggestion from a mediator, it should be somebody completely independent. So let's have a look at some scenarios that we might incur. So the first scenario, I just want to have a look here. Okay. The writing is too small on the screen, so I'm reading from my piece of paper. Sorry, guys. The parties agreed to early occupation, and an addendum is signed to provide for early occupation. Fantastic. The purchasers have moved in, and there's some portion of the property that is now significantly broken, battered, or bruised. Maybe a portion of the roof, or a door, or a broken window, or something similar. Maybe even something more expensive, like a leaking roof or pool. What are the options? Well, the first thing that we always do is we have a look at the offer to purchase. We have a look at the offer to purchase, what are the terms and conditions of the offer, and we have a look at the property condition report. What did the seller disclose? If the seller declared that the portion of the property is in fact damaged, the footstool clause will protect the seller. So if the seller declared that there's a leak in the pool, whatever, then the seller will be protected. But let's say he didn't declare it. I would suggest that, look, if a portion of this property is broken, battered, or bruised, I will have to ask the parties, listen here, was it like this when the purchaser viewed the property? Was that window broken? Was there a crack in the tile? No, quit, it wasn't like that. My tenants actually caused that damage when they moved out. Well, Mr. Seller, then it's easy. You're liable to fix it because the property must be in the same condition as when your purchaser viewed the property. So, Mr. Seller, we don't even have to negotiate. You need to fix it. And then obviously if there's a leaking pool, Mr. Seller, you didn't disclose it. No, but I didn't know. I haven't been staying there for the last 5 years. There's been tenants in the property. I really and truly didn't know. Then we'll have to go back to the purchaser and say, Mr. Purchaser, unfortunately, the seller is protected under the footstools because he really didn't know about it. Or the seller will say, oh, but you know what? Yeah, I forgot about that, man. Mr. Seller, we need to negotiate here. We need to make a plan because if you knew about it and you didn't disclose it, then the purchaser can turn around and hold you liable for damages. So let's make a suggestion. Let's get a quote, 3 quotes to have it done, and contribute maybe 80%, 20% because he's going to have the joy and use of a brand new pool for the next 5 or 10 years. So let's come. So that's how you negotiate and sit around the table. But you have a look at the offer to purchase. You have a look at the agreement. What does the agreement say? You have a look at the property condition report. What does that say? And then you negotiate. If that doesn't deal with the issues, then you start to negotiate. The next scenario, the seller consents to the purchaser starting renovations at the property before the date of transfer. Purchaser proceeds with renovating process. Later, however, the seller becomes aware. It becomes to the seller's attention that the contractors have taken occupation of the property. The seller thus seeks to claim occupational rent from the purchaser, and the purchaser claims that he has not had taken occupation of the property. So this is the prime example where the purchaser comes to you, Mr. Seller, and says, Mr. Seller, I just want to do some renovation. I want to paint inside. I want to do the garden. I want to, maybe build a little wall at the back door. I just want to build a wall there so that I'm protected from the weather when I go and hang the washing. So I want to build a little wall there, etc. So I'm not going to take occupation. I just want my workers to go there and paint during the day and maybe build a little wall and whatever. So, the occupational rental is minimal. Let's say the occupational rental that I could get is 10,000 Rand, but you know what? I'm just going to charge you 2,000 Rand. It's fine because you're not actually physically going to take occupation. You're just going to paint a bit. So, you know what? I'll charge you 2,000 Rand. It's fine. Now the seller becomes aware, hey, but people are staying in the property. The workers, the painters, everyone is staying there. They're using the toilets, they're using the electricity, they're using sewage. So now the seller says, but hey, I'll charge you 2,000 Rand just because you're just going to want the key just to paint. Now you're staying there. Your workers, whether you or your workers, it's the same thing. But your workers are staying there. So I should have charged you 10,000 Rand because obviously you are now housing them in my house. You don't have to get them a place to rent to stay at while they renovate you. This is unfair. And again, what can we do? We can only go back to the contract. What does the contract says? And if the contract says the purchaser will be entitled to do renovations at the property, he's going to paint and he's going to build a little wall, the occupational rental is 2,000 Rand. And that is all it says. Well then, Mr. Seller, unfortunately, that's all it says. It doesn't say here that he will not physically take occupation of the property. He will only take occupation as far as need his painters painting the property or building a little wall. There's no one going to stay overnight. The agreement doesn't say that. So I understand that that's not what you agreed to, but the purchaser can tell you, I've taken occupation, I'm paying 2,000 Rand, I've got the authority to paint and build the wall, so that's all I'm doing. So that's why it's important when the negotiations with regards to occupation and what will happen, everything must be in writing, because in that scenario, we'll have to go back to the purchaser and say, Mr. Purchaser, come on, man. Do you think it's fair that your workers are staying here and you know that that wasn't the original agreement? Yes, the original agreement wasn't inserted into the contract, but this is unfair. Your guys are using electricity, water, sewage. You can't expect the seller to pay for that. And then we negotiate and we come to an arrangement that he will maybe pay 5,000 Rand a month, etc., as opposed to 2. So that's how you then negotiate. But you always have a look at the contract. If somebody is unhappy, if somebody knows what are my rights, what can I do? Have a look at the offer to purchase. The offer to purchase will tell you exactly what you can and cannot do. So that is the story. Preventative measures are the best way to prevent dispute resolutions at a later stage when parties are aware, occupation, risk, all those lovely things, when the property condition report has been completed as best it could be by the seller and as honestly and openly as it could be. And if the party understands what the footnotes clause mean, and who's liable for what, then you might not have to go to negotiation, mediation, or arbitration at a later stage. So thank you, everyone. Enjoy the festive season, and I'm sure I will see you all in the new year. And